Welcome to the Law Awareness Weeks at CDC 2025. This webinar is part of Law Awareness Weeks at CDC 2025, a collaboration between Pro Bono SG, the 5 Community Development Councils, the National University of Singapore Faculty of Law, Singapore University of Social Sciences School of Law, Singapore Management University School of Law, the Singapore Corporate Counsel Association Pro Bono Chapter, and the Singapore Association of Social Workers, supported by the People's Association. I am Kelvin Kwek, and I am your host for this webinar. Today's webinar is a workplace rights and responsibilities. As you can see on the slide, we have many webinars coming up. If you're interested in any of the upcoming webinar topics, you can click on the link shared in the chat function to visit the website, to register for the next webinar, or many more webinars available. First, some housekeeping rules. Today, we will be using Pigeonhole Live for our Q&A session. You can submit your questions at any point during the webinar and also upvote on any question that interests you. If you have a smartphone or a tablet with you, just launch your internet browser and enter www.pigeonhole.at at the address bar. Next, key in your event passcode, which is Law CDC 2503, as shown on the slide. Alternatively, you can click on the link shared in the chat function to launch Pigeonhole Live. If you are viewing this webinar from a desktop or a laptop, you should receive an invitation to launch Pigeonhole. Please note that today's discussion is not intended to substitute any form of professional legal advice. If you require specific legal advice, please consult a lawyer. With that, I would like to introduce our panelists for today's webinar, Do Wei and Patrick Tay. Wei is a partner at Harry Elias Partnership LLP, specializing in commercial litigation involving issues of contract and employment. Her experience also includes non-contentious aspect of advisory work pertaining to employment matters and commercial matters. Patrick is the Assistant Secretary General of the NTUC and also Director of NTUC's Legal Services and Strategy. Concurrently, he's an elected Member of Parliament and a member of the NTUC Central Committee. He chairs the Government Parliamentary Committee, or GPC, for Education and is a member of the GPC for Law and Home Affairs. He has been representing the labor movement in all the tripartite work groups to review and update employment and industrial relations legislation. Wei and Patrick, thank you for joining us today. Singapore's employment landscape is shifting fast. Staying informed has been very essential for both employers and employees. A good understanding of your rights and obligations as an employee under the Employment Act is important, especially in a tightening labor market due to uncertain economic times. In today's webinar, we will discuss employee rights and obligations at each of the 3 stages of your employment, namely pre-employment, during employment, and at the end of employment. We will discuss the relevant provisions in the Employment Act, Workplace Fairness Act, and the various tripartite guidelines, standards, and advisories. If you're an employer, we have not forgotten you. We will discuss your compliance obligations and how companies and businesses can adapt its HR practices to meet evolving legal expectations. So whether you're navigating these changes from a business or an employee perspective, I hope you will find this webinar to be beneficial. Now let's begin by discussing legal issues that may arise at the pre-employment stage. Starting with Wei. Can you share with us how the Workplace Fairness Act and the tripartite guidelines on fair employment practices, or TGFEP for short, how do they regulate recruitment at the pre-employment stage?
Thank you, Kelvin. Good evening to all the participants of the webinar tonight. The Workplace Fairness Act. This piece of legislation has not actually come into effect yet. but I believe it will be soon. Perhaps Patrick will be more well placed to let us know roughly when it would come into effect. But I think what is going to be included in the Act is quite clear. The purpose of this Act is to prevent and to discourage any discrimination of employees by employers at, in fact, all stages of employment, not just at the pre-employment stage, meaning the recruitment stage, but as well as in employment and also at the termination stages of the employment. Now, at the recruitment stage, I think maybe many participants may already be aware that there are some guidelines that are required of employers right now in terms of job advertising, in terms of their choice of employees at the recruitment stage. Now, these guidelines will be enshrined in the Act that comes up, I think largely similar in nature. And I think the key aspect of the Act is that it prohibits discrimination in respect of a specific 11 protected characteristics. I'm not going to recite all 11 characteristics. This is something that I think all the participants, you can find the information quite easily online. But what I would want to highlight are some of the key things like age, gender, your marital status, pregnancy status, race, language, and religion, of course, and any disability and mental health conditions. So these are part of the 11 protected characteristics that, in respect of which employers cannot discriminate. Now, this Act has, maybe if I can just touch a bit more about the Act, just maybe beyond the pre-employment stage. I think also even in the in-employment stage, it requires employers to act fairly towards employees in terms of issues like promotions, deployments. Decisions should only be based on merit and not on any other characteristics, especially the 11 protected characteristics. Now, I want to highlight also that the TGFEP, which is something that has been enforced in a long time, or rather in effect in a long time, this continues to remain in effect even though this workplace fairness legislation is coming up. I want to highlight that at the commencement of it, there are exemptions to complying with the Act, meaning that firms with less than 25 employees are exempted from compliance with the Act for at least the first 5 years. And however, it remains that all firms, regardless of whether you enjoy the exemption, you must comply with the TGFEP because it is still in effect. Now, this Act also has some obligations, additional or rather specific obligations for employers. Things like I think one item that stands out is that employers need to now have proper grievance handling procedures for their employees. I think right now the current landscape is that maybe some bigger companies have this, but some smaller companies may be a little bit lacking in this area. So when this Act comes in force, companies which have to comply with the Act, they will be required to have this process in place to notify the employees of it so that this can be used by the employees in the event of any workplace grievances. Well, and I think in terms of termination-related issues, I think it remains similar to the current landscape, in terms of preventing any wrongful dismissal, including based on issues of discrimination. And of course, any claims that arise from any breach of this Act will be dealt with by TADM and the Employment Claims Tribunal, which is the current framework that is being used anyway.
Patrick, can I ask you, if employees outside of the 11 characteristics are discriminated, what happens to them?
Sure.
How are they protected?
Yeah, thanks, Kelvin, for that question. And I would like to also tag team with Wei to share a bit more about the Workplace Fairness Act. Partly because I have to declare my interest. I'm part of the tripartite work group that actually helped in the promulgation of this new Workplace Fairness Act. So I would like to use this opportunity to give everyone a bit of about the genesis behind the act and what lies ahead. Before I touch on some of the things that that some of you may be concerned with, like what do I do now, before the act is enforced, and what if I get discriminated with over characteristics that are outside of the 11 protected characteristics. Then I'll take that. But I thought to share with you, many of you may not be aware, actually, about 3 to 4 years ago, Prime Minister actually at the National Day rally did talk about the need to make sure that, we in our very multi-generational, multinational, multiracial, multi-religious sort of country, that we need to have laws to in a way stay really relevant and resilient to many of the changes that are happening. I think so I would say I strongly welcome this because I've been lobbying this in Parliament quite a number of years ago, and I never expected this piece of legislation will actually come into force in my lifetime, because it's quite a big move and quite a bold move, I would say. Because we are aware in many of the other jurisdictions, like in the US, the Equal Opportunities Act, in the UK, in Australia, that's they already have such anti-discrimination legislation. But Singapore, this workplace fairness is a first of its kind, quite watershed in that sense, because it's the very first time that we are introducing sort of like an anti-discrimination piece of legislation right here in Singapore. And what's so unique, if I may add to what we shared, is for the very first time we are covering pre-employment, in-employment, and post-employment. So it's quite interesting. We can cover the whole spectrum of employment, and I thought to highlight some unique parts about the protected characteristics. As you know, in Singapore, because of aging population, because of the sandwich generation, and many other, and we have very, very small nucleus families. So there is actually two things that came up quite a bit, learning from what's happened in the pandemic. One is, as we alluded to, one of the protected characteristics is on mental disability or condition. So that's something which came up, and we have included that as part of the protected characteristic. The other one is actually caregiving arrangement and responsibility. So actually, for the very first time, many of us, including myself, we have elderly parents to look after, elderly parents-in-law to look after, young children to look after, and so various obligations. And therefore, caregiving has become quite an important topic at the top of the minds of many Singaporeans as well as workers as well. So therefore, we have included this as part of the list of 11 protected characteristics. So these, I thought, are some of the more salient, more important ones. But I just want to re-emphasize the fact that, yes, we have the 11 protected characteristics, but actually the main operative word is actually an adverse employment outcome, meaning that things like workplace harassment, workplace bullying will not be covered within the ambit of the Workplace Fairness Act, because there's the Protection for Harassment Act and the POHA courts. So that would be the right forum to make your complaints if you're, from sexual harassment to even bullying in the workplace. So that's the forum for it. For this workplace fairness, specifically is on discrimination and importantly the 11 protected characteristics. So it's 11 protected characteristics as well as the adverse employment outcomes. So these two is the very operative words of the Act. So what if you want to have access to file a complaint if at this juncture we have people who are unemployed looking for jobs, at the same time also a bit worried when there are layoffs, retrenchments. We hear lots of stories, lots of publications on this, and if we do really genuinely fall into some grievance, so the current forum is still available, because as what Kelvin alluded to, there's actually and Ray too, there's a tripartite sort of a guidelines on fair employment practices, usually FEP for short. So there's already in existence tripartite guidelines to ensure fair and progressive employment practices. And who administers that? TAFEP. TAFEP is a tripartite alliance for fair and progressive employment practice. It's a full-time tripartite powered by tripartite alliance. And there's a team full-time looking at such discriminatory complaints by workers or job seekers. And that will continue to be enforced because, as you know, although we don't have the Workplace Fairness Act enforced yet, we already have the TGFEP for quite a number of years already. So, in fact, TAFEP sees about 300 complaints per year in the last 3 years in relation to some of these discriminatory complaints. So these are examples and gives you a sense of what it is. And so that's what's enforced today. But as what we said, I thought, not really letting the cat out of the bag, but we just passed the legislation earlier this year in January. There's a second round of amendments, or should I say introduction of the mechanisms, how we're going to mediate, adjudicate, and basically the mechanism and the framework behind filing workplace fairness complaints will be out later this year. Later this year. So you would expect to see it being introduced as a new bill, a bill in Parliament, possibly adding on to the Employment Claims Act, because the Employment Claims Tribunal will likely be the forum hearing workplace fairness claims. So all of us are familiar with DADM, ECT, and of course now we have TAFEP as well because of the discriminatory practices. So that's important. That's coming up later this year. And later this year, possibly during the second reading speech, we'll hear more when the exact date and time the act will be enforced. Yeah, possibly 26, 27. We'll hear more. Frankly, it's not. They're still deciding on this, and you'll hear more details later this year when the bill goes for a second reading. And finally, to answer Kelvin's question, I went quite a bit before going to that point on what if you are discriminated in categories that are outside of the 11 protected characteristics. For example, sexual orientation. Then what happens to you? I mean, where do you have recourse? I mean, minus the civil courts. Of course, you have actually the TAFEP still in place. The TGFEP, or as I alluded to earlier, the Tribunal Guidelines on Fair Employment Practices will still be enforced. It will not be expunged or repealed because of the new Workplace Fairness Act and its mechanism. So that it will still be in existence. So that will cover all the other complaints or grievances, discriminatory nature. They're outside of the 11 protected characteristics, or even they are exempted by virtue of the fact that there are exemptions in the Workplace Fairness Act. So I thought just to clarify this, that and in fact this was articulated quite clearly when we posed this question to Minister when the Workplace Fairness had its second reading. He did mention as well this very fact that TAFEP and TGFEP will still be enforced, and so that will be covering all the other kinds of discrimination that may be outside of the ambit of the Workplace Fairness Act.
Thanks, Patrick. Maybe I'll just change a bit, and let's use a scenario, and maybe we can use this to flesh out how the Workplace Fairness Act works in practice and may work in practice. So there's the scenarios like this. Mary made a short list for her role as an accountant. During the pre-employment checkup, the doctor found that she was pregnant. The company subsequently withdrew the offer, saying that the role was not suitable for a pregnant woman. Mary thinks that she has been discriminated because she thinks the role is desk-bound. What can she do? Wei, the lawyer, from the lawyer's perspective, what do you think? Does Mary have any recourse?
I think certainly this looks like a case where there possibly is discrimination. I mean, the role as an accountant, and traditionally it is a desk-bound job. It's not something which that she needs to be on site, for example, at a construction site or anything like that. So it certainly looks like a possible case of discrimination. However, I must caveat that I think the employer's perspective and the employer's position also has to be sought to understand what are the reasons why the employer has felt that she is not suitable for the role. So I think in deciding the issue of whether there's discrimination, both sides of the story have to be heard to determine whether indeed this decision has come about as a result of discrimination on the employer's part.
Right. So if it went before TADEM, for example, then the mediators would look at both sides to see whether there was a case, and then from there they might proceed, right? I assume that's how it's working.
Essentially, looking at the evidence, I think all these claims and grievances and issues, whether they are mediated before TADM or even ECT, requires a lot of evidence. So probably both parties need to show sufficient evidence. I think it's such comments that are made, if there are comments that are, or slight remarks that are made, all these are actually useful evidence to make a case for a discriminatory practice that's been executed. So definitely, I think, of course, the Workplace Matters Act is not enforced yet, but even on face value, prima facie, based on what is shared in this facts of this case, I think that there are a few things we can pay particular attention to. Firstly, I definitely a possibility of a complaint to TAFEP. You can actually do that for discriminatory practices based on her maternity status, as well as sort of like to a certain extent gender or sex discrimination in that sense. So that's one important thing. I thought we should, he or she, whoever faces this scenario, should file a complaint. But the other thing is also, if you look at employment law or employment, this sphere of employment issue or labor law in general, especially when it hits onto maternity benefits. As you know, Singapore, we have maternity benefits that are locked into several pieces of legislation, particularly for Singaporeans and locals. You have actually certain rights, maternity rights, and it comes with some value, intrinsic monetary value. So therefore, actually, there may well be claims which can be made. Because usually in an employment relationship, or in this case, it's a pre-employment thing. In most employment cases, especially if the case is already a bit acrimonious or it's contentious or it's been filed to the relevant agencies, the relationship between the employer-to-be and the employee-to-be would have been a bit more already quite sour. So usually, it won't be a situation where there's a forced hiring or reinstatement or whatever of that potentially enforced employment contract. So that's usually not the case. Usually there may be a requirement to pay notice pay, as well as the relevant maternity benefits, which she may be entitled to. And now, beyond maternity benefits, there's also paternity benefits. So therefore, all these are things that you need to look out for. And then the question is, I know Kelvin is going to ask me, what if it happens just the day before she starts work? Technically, unfortunately, the employment contract kicks in only after the first day of work. So there's starting to stop employers or employee not starting their first day of work or terminating prior to the first day of work. But however, so it's good, probably where you can weigh in on this to read what is you sign on a dotted line.
Yeah, correct. So, for example, you sign on a dotted line. As an employee also, I think it cuts both ways, right? Employees can say, oh, I have a new job now. I don't really want to start with you because I'm getting to 15% more on the other job. And then I don't turn up to work.
Yeah.
As an employer, you also feel like it's not fair. What will employees do? And will employees get in trouble?
Well, I think, like as Patrick mentioned, the problem is that the Act and its rights don't kick in until you actually start work. So when it's like even a day before your employment begins, then the recourse only lies in the contract that is signed between the employee and the employer. Now, I must say that in practice, I see both sides happening, both sides of the coin happening. Employees who inform the employer the day before,
or they don't turn up.
Oh yes, absolutely. They just simply don't turn up for work. And the employer is left. I mean, a lot of people have this idea that it's no big deal, the employers have other people to cover. But that's actually not true. I mean, especially some smaller businesses, where really every employee counts and the employee is there for a specific role to cover a specific project, for example. I think employers are also left in the lurch. And similarly, I think for employees, I think needless to say for an employee, I mean, if you were to be offered a job and therefore give up, your job hunt, in reliance of that job offers, of course, the impact is great. So what we see sometimes in employment contracts are clauses where it is written in that should you decide to
No show, right?
no show or maybe simply terminate the contract. So the contract being something that takes effect from the day you sign rather than the day you start work. Okay, so in a scenario with that, where the contract is terminated before the first day of work, it is treated like a resignation or treated like a termination where notice pay has to be paid. I mean, like Patrick said, I mean, at that point in time, insisting on somebody coming to work for the notice period may not be very practical anymore, given the relationship. So it becomes a matter of the notice pay. So maybe 1 month or 2 months notice pay if you terminate the contract even before the first day of work. And ideally, I think in fairness, it should probably cut both ways for the employer and the employee. I will, however, be very honest in saying that sometimes for employees, the bargaining power is not as such. So often you may see contracts where this clause is unfortunately just one-sided. So if the employee has a no-show, then yes, notice pay kicks in, or maybe just simply a lump sum payment. And the equivalent is not catered for in terms of the employer retracting the offer. But I think at the end of the day, there is still the possibility of a civil claim that can be considered depending on the factual matrix of the case. That being said, again, I take a very practical perspective about this, which is that often the amount is not large enough for this to be pursued. So that is also, I think, a problem that we see in practice.
Yeah, and I suppose a lot of this is also just limited to like could be a salary in lieu of notice, right?
That
So
Yes, yeah.
amount?
it's and it could be in some contracts I've seen the salary in lieu of notice for a probationer is less than the regular confirmed staff. So like for example, the regular staff could be 1 month confirmed, but if you are on probation, it's 2 weeks.
Yes.
So you really are like in Mary's case, she might only get 2 weeks salary. And she might have lost, then her previous employer, current employer, doesn't want her back, and then she's stuck without many options. So I think that's where I suppose, Patrick, from your point of view, the unions can step
Yes.
in and
So in the unionized environment, of course, in this case, she's not entered into an employment relationship yet. So she's technically not a bargainable employee within the company. The agreement doesn't cover non-employees. And therefore, that's the difficult part. We can't really activate some of the the provisions of the law to help, and all the provisions of the collective agreement. However, if he or she is in this case, if Mary is a union member, and we will want to walk the journey with her. And this is not this is not something we talk of as in this hypothetical, but I do have actually witnessed real cases with a very, very similar factual situation. Maybe not an accountant, but in very, very similar circumstances. So what we do at TADM, we have our NTUC colleagues there. So if you are a union member, if you're not a union member, please join. If you are a union member, the good thing is that we will advise you and we will try to represent you to the best of our ability to secure some compensation from the would-be employer. If again, it boils down to whether the evidence and the facts are clear enough. If not, then there will be some form of conciliation or mediation at the TADM.
Right. So it all boils down to evidence at the end of the day, right? And yep, okay. So maybe before we move on to the next stage, which is in employment, could I ask Wei and Patrick, maybe if we can provide some takeaways for the employers who are listening in, some things they can think about for the recruitment stage. What do they need to put in place to prevent these things from getting to comply with the law? What do they need to comply with the law?
I alluded to earlier, the tripartite guidelines on fair and progressive employment practices, GGFEP for short. All of you will have been or would have been quite familiar with it because it's been in operation for quite a while already, quite a number of years. So acquaint yourself with that, because it does outline some of the key principles and tenets on to ensure fair and workplaces. I think that's important. And now with the upcoming Workplace Fairness Act, and it's the second deck of amendments that are coming up later this year.
Include penalties, right?
Yes, that's right. So there will be some sanctions both ways, whether it's frivolous claims or whether it's employers who are as complaints shot at them. So do acquaint yourself, but not to worry. In fact, as part of the Law Works partnership between NTUC and Pro Bono SG, we are doing up a pocket series on this to give you a sort of like a simple, easy to read guide come next year. So we are in the midst of waiting for the second piece of deck of amendments, and then we will roll out this easy, handy guide, which you can receive free of charge, PDF copy, just like all our earlier pocket series that we have done. The other one is also there will be quite a number of outreach and sharing sessions of the combined effects of both this year's Workplace Finance Act as well as the upcoming deck of amendments next year. So look out for it. Whether you're an employer, whether you're HR, human capital practitioner, or even a consultant, or even an employment lawyer, you can have access to sufficient materials. So look out for it, and look out for all these sessions, which will, I think, if I'm not wrong, will all be done free of charge. And you can just sign up for them. And we are also planning for some sort of a legal primer as part of our Law Works partnership to share the working details. Now that by next year the light and the tunnel is clearer. At the end of the tunnel is clear that we know when it will be enforced, and the things that within the perimeters, what can be filed up to ECT, and we hope. Actually, in fact, I've been lobbying our tripartite partners to provide more clarity on what evidence is sufficient to mount a complaint under the protected characteristics, as well as file an action in to the ECT. So all these will be upcoming. So not to be worried, not to be too flustered. Yeah, I know the big companies like what we mentioned, you already have very, very strong procedures. But I think the others, the other view of maybe small and medium enterprises, micro SMEs, or even startups, trust that we will be providing a lot of infographics, materials. In fact, the Workplace Fairness Act has a short 1, 2, 3 pager infographics, which I believe we'll be pushing out the link through tonight's webinar, which you can access through the chat. And again, stay connected with us through our various social media platforms. So you'll be very sure that you will be acquainted and given the very, very basic understanding to be able to be an effective manager, company, as well as HR practitioner.
Well, maybe I'll share something from a very practical perspective, since my job scope primarily involves disputes, including employment disputes. So I think now, given that the Act and the amendments that are coming up prohibits, or rather prevents, discrimination at all stages of employment, I think it becomes very important for employers to understand how is the best way for them to maintain records of certain decisions that they make in respect of the employees. In terms of recruitment, I think unemployment is something that has not really been in focus, in terms of employers. So things like, for example, if a decision to promote someone or the decision to redeploy an employee, why is this decision made? I think given the ambit of the Act, I think there now needs to be some thought as to what sort of records the company needs to keep in the event that it is met with a claim for discrimination by the employee. I'm sure the process and whatnot, it would have been proper, it would have been gone through in the past. But I think the problem now is that if you need to meet a claim, you need to meet allegations of discrimination, you now need to have good documentation in terms of the company's internal records. So at recruitment stage, at employment stage, promotions, maybe reasons to terminate, appraisals of employees and whatnot. So I think companies need to beef up a little bit on this aspect. Even for the companies which are exempt right now, the smaller ones, I think it's good. I mean, the exemption probably will not last forever. So it's probably good for these companies to also start considering how they can put in place these grievance handling procedures and also anything else that they need to do in order to comply with the Act in near future. I think I would also say this, apart from simply the purpose of complying with the Act, I think generally, from what I see in my work experience, when there are these processes which are properly put in place and communicated to the employees, and standards and expectations are properly communicated, I think generally it leads to a more harmonious workplace, better relationship with the employees. I mean, even in this scenario that we have, I mean, if the company had genuine reasons for withdrawing the offer, I mean, if they had been communicated to her properly, then perhaps, much of this dispute could have been avoided or mitigated. I mean, of course, if it's a case of a real discrimination, then there's nothing to be said. But in the case if it was genuine, and I think good communication would have avoided at least part of the problem, and it could be spoken about. So I would say really, consider what needs to be done to comply with the Act. But I think it goes beyond just the purpose of complying with your legal requirements.
Thank you. Question regarding the 25 employees in the Workplace Fairness Act. It only applies to companies with more than 25. Was there a reason why they excluded this for now?
The current thinking is that I think much appeal from the employers, because I think for the smaller firms, it's quite onerous. There will be compliance costs, and therefore we arrive at that magic number of 25. But if you recall, Minister of Manpower during the second reading actually did allude to the fact that they'll review this in the next 5 years and possibly make it universal. But for now, less than 25, they are exempted.
Okay.
Workplace Fairness Act.
Well, thank you very much. Thanks, Patrick. And to our audience, or if you are still out there, please submit your questions at any point during the webinar. You can also upvote on questions that you already see on the screen. So keep your questions coming. Thank you. Now let's move on to the next stage of the employment journey, which is in employment. And we've covered a lot already about discrimination and workplace fairness. So I will skip that and we'll move into something that is, I think, may be of interest to our listeners. It's on flexible work arrangements. So everybody, as far as well, my kids love it. Would love to work from home or remotely if they could. The trend started during COVID-19 pandemic, and many employees I know still choose their employers based on their employers' flexible work policies. Patrick and Wei, maybe you can share some of the best practices that employers can adopt to make this work for them. And also from the employees, I mean, it's not like a blank check, right? What do they need to do to invoke these arrangements?
Yeah, I think if I may start the conversation, I think for employers or all of you out there who are really examining, particularly if you are in employment and looking at flexible work arrangements, a very, very good starting point would be the tripartite guidelines on flexible work arrangements. And it's just been rolled out not too long ago, last year in December. So actually that will be a good reference point to, it's a nice, if I'm not wrong, it's 7, 8 page or 9 page document, which you can refer quite easily to. You can Google it and then you can get a copy of it. I will try to provide a link to it later in the chat, and you can access that. Why do I say that's useful? Because it's quite instructive both for employers, HR practitioners on what basically allowing employees now to make requests for flexible arrangements. So we have actually some guidance notes and points on what flexible arrangements are, and then there's also a template on how we can implement some of these best practices in allowing employees to apply for flexible arrangements. But I would like to, really do a call out and not so much a caveat, but a call out, because I think a lot of people equate flexible arrangements as working from home. I just wanted to dispel this myth. Flexible work arrangement is not new. In fact, NTUC and the labor movement, we have been evangelizing and advocating for this for more than 2 decades. Particularly with trying to encourage more women back to work, as well as to allow more workers to be able to balance work and life and other caregiving arrangements back home. Usually caregiving arrangements. They could be elderly parents, young children, or even siblings who need care, or even maybe because of special needs and requirements that they need to take time away from work or work in a very unique work arrangements. So in that, the flexible arrangements in Singapore, it's a tripartite thing. That's why we had the tripartite guidelines. But more importantly, remember these 3 key tenets of flexible work arrangements. It implies flexi time, flexi place, and flexi load, LOAD, load. So take note, flexi time, of course, to avoid the morning jam, sometimes we give some allowance, or for workers to come later, or because of caregiving arrangements, enter the workplace earlier, and then leave earlier so that they can pick the children from the childcare arrangements and stuff like that. So that's flexi time. And of course, flexi load. Some may be because they are not able to commit a full day, for example. Or they may be going for a dialysis treatment in the afternoon, for example. And they can only work in the morning. So that's where they take a lighter load. Of course, these examples of flexi load and of course flexi place. So work from home is but another option or another alternative within this concept of flexi place, meaning well, depending on the nature of job. Not all jobs can be work from home and could be flexi, particularly the frontliners. Yeah, you can't tell a bus driver you work from home. Yeah, otherwise you won't have a bus, or
You can't tell the receptionist at the office you can work from home.
although now we can use
That sometimes happens now, actually.
use Gen AI and RPA
With a screen, then
robotize everything. And you get a avatar. But otherwise, most of the frontline and high touch jobs, we are not able to implement work from home and maybe flexi place because of the nature of the delivery of the job and service. So this is, I thought, some brief summary of for those of you out there wondering what's flexible arrangements in Singapore. It's flexi time, flexi place, and flexi load.
Good practices. I think that's what Kelvin asked. I think best practices, good practices would be such where you are able to avoid a mismatch in expectations, as to what this FWA can entail. I've read the tripartite guidelines on this topic, and frankly, I would say it's very comprehensively written. And the guidelines take into account the employer's interests as well as the employee's interests. So, I mean, whilst it entitles the employee to make an application, a request to the company for a flexible work arrangement, but I think also, in fairness, it sets out certain scenarios where it really is not suitable for that to happen. And therefore, employees should also have that understanding in mind, that in certain scenarios, it just is not possible. I mean, for example, a newcomer to the company, I think it might be a little bit difficult, and also practically not less than ideal for the newcomer to start working from home immediately. I mean, you enter a company, you need to understand its culture, you need to understand how the workplace functions. So I think the tripartite guidelines strikes a very good balance between the interests of the employee and the interests of the employer. The guidelines also encourage employers to, or perhaps requires employers to have a proper policy on flexible work arrangement. I think that is great, and I think there should be some thought put into it in terms of helping the employees understand their expectations of flexible work arrangement. So, for example, if the company has certain areas or certain fields of work where it just is not possible, or certain limitations on that, I think it is helpful to set it out in the policy so that the employees, before they make the request, they can have these considerations in mind, so that I think it reduces the mismatch of expectations and reduces the disappointment that might come with a negative response to the arrangement. I think it also helps the employee calibrate the request. So, for example, like Patrick said, the 3 different types of flexi, what could work for the employee as well as the employer, so they can calibrate that accordingly. And also, like I said earlier, good communication. Again, something that is required by the tripartite guidelines, which is to communicate to the employee very clearly if certain arrangements cannot be accommodated, and perhaps work with the employee to see if a modified arrangement can be reached, or perhaps maybe a short-term arrangement can be reached in order to address the employee's needs.
Thanks. And I suppose the message from the top and the buy-in from top management is also very important, right? I mean, there's no point having a policy that is just a piece of paper. I suppose that it's important for the organization to have training. Everyone understands it, not just HR, but also the top management, the chief executives, the owners must also walk the talk.
Yes, absolutely. I think they set the tone, but you're absolutely right that, this is not just a HR problem.
Mm-hmm.
I think supervisors, middle management, anyone in a management role needs to understand that, there's this policy in place and the rationale for the policy in order to properly execute it.
Great, thank you. Let's move on now to another topic of interest, second job and gigs. This was accelerated also by COVID-19 pandemic. In July, in the Straits Times, it was reported that a growing number of full-time employees, especially millennials and Gen Zers, were pursuing side hustles not just to supplement their income, but also to seek personal fulfillment. Let me share this scenario with the audience, and let's have a chat about how this side job thing works in practice. So we have Shamala, who works full-time as a graphics designer. She loves flowers, and during the COVID-19 pandemic, she started a online florist from home. She single-handedly managed the website, bought fresh flowers from suppliers, did the arrangements, and then delivered them to the customers. Over time, the business grew, and during peak periods like Valentine's Day, she would be flooded with orders to the extent that she struggled to juggle the demands of a full-time job with her side hustle. Wei, is it legal in Singapore to have a side gig, side job, side hustle?
Well, I think it all depends on your contract with your employer. What we commonly see is that usually when there's a full-time employment, usually you will see a standard clause in the contract that says that you are expected to devote all your time and attention to your employment, to your current employment, and you're not allowed to take up any side employment, which includes these side hustles and gigs. Well, often, or rather sometimes you will see that in the contract, they may say, without the written consent of the employer. So which means that I suppose it opens the door for you to seek the employer's permission to engage in a side, gig or a side job. And ultimately, whatever it is, whatever the employment contract says, even if it doesn't talk about an exception where you can ask the employer for permission, ultimately, again, communication is key. So if there really is this need or this interest in pursuing a side passion, then ask your employer. At the end of the day, the terms of the employment contract can always be varied by mutual agreement of the parties. So I think that is key. But I would say generally the contracts have this clause. So very often you would end up being in breach of the employment contract if you take part, in a side job, especially if it's something where it's really profit earning, and substantial amount of time is dedicated to it.
Right. So, like in this case scenario, like Shamala during Valentine's Day or that period leading up to Valentine's Day. She's just focusing on her florist job. It will probably be impacting her day job. Huh?
Yes,
If you-
absolutely.
yeah,
Yeah.
that will be a problem. Patrick?
Yeah, I just wanted to extend a note of caution or warning to all our listeners or attendees or participants this evening that as what we alluded to, if you really do get involved in a side hustle, a side gig, or some form of secondary employment, my recommendation is always do full disclosure to your employer, because as what we alluded to, in most employment contracts, even if not employment contract, sometimes you just see the employment contract, it may be a 5-6 page document, but there are also HR circulars and manuals that are embedded within the old, maybe in your intranet or somewhere. So I think it's good to be better to be a bit more conservative. Do get permission to carry out through your reporting officer or through HR. If you want to embark on anything that's a side hustle that may compromise your work. In this case, yes, because because of fulfilling orders, you may have to, compromise your actual day work. And a worst case scenario would be will come a point of time when there's a conflict interest situation.
Oh yeah, for example, when she starts using her office PC to take orders.
Or deliver all the flowers to the office. Or start soliciting using company time, company resources. So it's tricky, it's tricky. So my note of caution to everyone, just be mindful and to be careful. I don't want you all to lose your jobs because this may be tantamount to behavior or conduct which may give employers grounds to terminate you. So I don't hope you get there. And therefore, please do your full and frank disclosures. Do get your permissions, your consents. Just like public sector employees, they're not allowed to take side hustles. If you're even going to engage in some form of employment or some form of other external appointments, not even employment, appointments, there's a requirement to seek permission. And the permission is got granted, you're not supposed to do it. You can't do it surreptitiously or, behind the scenes and stuff like that. So I just worry for all of you, particularly in the public sector where there's a government instruction manual covering some of these arrangements. So be extra careful and don't compromise your day job and your main job.
So it looks like the message here is full disclosure to your employer. And work with your employer to understand why you're doing this and how it'll impact your day job. I mean, I can think I've come across examples where, he was doing a consulting gig on the side and he was going to use the marketing material from his employer as part of the consulting. Now, that would have been a big red line because this is a disclosure of trade secrets that would have been problematic for the company. In another case, this person was helping the parents' restaurant or food stall at night, and so these things, at the stalls that will run into the late night, and next morning she has to get up to go to work at 8 o'clock, 9 o'clock, and then she'll be half asleep at the desk. So that would also be again detrimental to your day job.
But at the same time, also I encourage employers out there to consider the request and all these disclosures, with some sense of empathy and progressiveness as well. Why? Because sometimes some of these side hustles which your employees will undertake may be things that provide them with a second skill. Yeah, for example, I know this particular person does a day job in the financial sector. I remember this case because it happened during the global financial crisis. Someone was doing a financial sector job, lost a job, and because she in the free time she did some diploma in counseling. She did it sort of like counseling work in the weekends in church and stuff like that. So that was her second skill. And not just selling financial products, but also very strong people skills in counseling. And therefore, sometimes if they embark on some of these things, sometimes maybe paying, non-paying, paying, or maybe honorarium and stuff like that. So to also take it, look at it carefully, examine carefully. Don't think that as a second job means no go. No, you can't do that.
It could be very persuasive after all
it
the
could be
details,
actually helping in many of our fellow workers' employment employability. Because if a second skill, then in event you lose or there's a downturn or a cyclical unemployment, and at least him or her can quickly segue into the next using her other skill or a second skill or second gig that he used to do. So actually, it's quite a good buffer, or should I say, sort of like an insurance of sorts with some sort of these side hustles.
So it looks like companies also need a second job or a gig policy. Yeah? It would be good to have one, I think.
I think it's performance. I think ultimately, if it doesn't affect the job performance of the work performance of the employee, I think that's key for employers to consider. I mean, it must be recognized, that people have passions outside of work, and sometimes if you have a happy employee, it pays off,
Happy employees stay in the company. They do better. And that's
Right, don't affect your work performance.
Not just happy. Sometimes they may be healthy employees because they may be a Pilates instructor on the weekend.
Exactly. Yeah. So yeah, I would say be flexible, I think.
Yep.
Yeah.
That's good. Okay, well, let's move on to the next section, which is the end of employment. So this one, I think I see a lot of questions regarding this. So I think looks like it's going to be a hot potato for us as panelists and for me as moderator. So over the last 12 months, unfortunately, we've seen several companies who are carrying out retrenchments who've made the news for the wrong reason. And lately, there's one company the last week or 2 weeks ago. Patrick, what are some of the ways that employers can carry out retrenchments in a responsible manner?
Yeah. Well, this is a very important topic, very sensitive one, as well as one that can be very emotional. Personally, I've been involved having been in the labor movement for the last 20 years. Countless number of retrenchments, and particularly the last couple of years, being with the electronics and electrical industries, we've seen personally, been involved in like 7,000, 8,000 layoffs the last 3 years, and we know it's a difficult time, and therefore, fortunately, we're at a tripartite level. Again, you notice in Singapore, everything is tripartized, from workplace planners to flexible arrangements, and even in retrenchment, we have one important document. Why do I need to allude to that? I think we'll try to provide the link to that document. It's called the Tripartite Advisory on Managing Excess Manpower, quite mouthful, TAMEM, TAMEM, and they added on responsible retrenchment. So very important, if any of you who are maybe employment lawyers, HR, human capital practitioners, employers, owners of businesses, or even workers who are facing impending job loss through layoffs or retrenchments, can refer to the Tripartite Advisory on Managing Excess Manpower and Responsible Retrenchment. Quite a mouthful, but TAMEM for short. And that gives you some guidance points on the various aspects of retrenchment, how it should be carried out, early notice, notification, and the payment of retrenchment benefits. What's the not so much the market rate, but what's the industry practice, and finally, how to do it. More importantly, not just in a fair manner. I mean, in Singapore, unfortunately, retrenchment is something we can't stop employers doing, especially if they can justify it, although we try to cut costs to save jobs, not cut jobs to save costs. So we try to use retrenchment as a final last resort, whether it's a unionized or not unionized environment. And we want employers to not just do it fairly, but more importantly, responsibly, and if I may say, progressively. I've personally encountered and worked with companies that have done it very progressively. So progressive until the day when there was a actual retrenchment exercise. Workers were not angry or crying. They were actually quite smiling and happy, because they were segueing into the next job, already all skilled, and mentally very, very prepared, not caught by surprise and not given any curveballs at them. So I thought that would be a good starting point, TA at TAMEM. And over and above that, if you are in a unionized environment, not to worry, you have to read TAMEM, just go to your union leaders and NTUC and Labour Movement will be more than happy to walk the journey with you to ensure that things are done not just fairly, but responsibly and progressively. More importantly, as what Kelvin alluded to, a few near misses that we have seen, or in fact, real misses that we have seen in the last 12 to 18 months. There are quite a number of very, very high profile retrenchments. I've been involved in a few of them. The key thing is, I thought, having learned from some of these not so good retrenchments that were done or executed, I think the key is communication. Communication comes in a few forms. Early notification is highly, strongly recommended. Early notification
To the employees.
to the employees. And if you are in a unionized environment, to the unions as well. In unionized environments where there's a collective agreement, usually we build those clauses in of early notification, even before the employees are informed. Not so much we want to stop the retrenchment or layoff. Of course, we will try to understand the company's rationale for doing it. Sometimes it's a higher HQ decision. Sometimes the company is really in the doldrums, no longer a going concern, short of liquidation. They really need to execute that to stay above water. We totally understand that. But early notification, we can't stop it. The retention, but early notification allows the unions and the various agencies to render support to the company, and also render support to the workers. Because the main thing is we want the workers to segue to the next job as quickly as possible. Why do I say we need to do that? Because we have noticed through the last decade or so of labour market stats, workers who stay out of a job after being laid off or terminated, the longer you stay out of job, the harder it is to re-enter and find the next job. So therefore, we are providing a lot of resources to my colleagues at E2I, Workforce Singapore, providing a lot of support, even prior to the actual retrenchment date, to do a lot of preemptive support. Where we provide some training. Some of them may not even have written resumes and CVs for the last 25 years of their lives. And now here they are faced with this this daunting task of having to come up with a CV. Of course, now we have JDI and all the other resources. It's much easier. But really how to prepare for interviews, how to even dress up and prepare. And just to share some positive experiences, they have companies that have informed us about possible retrenchments as early as 6 months ahead. And I don't mean small companies, big companies, and some of them even listed companies, informing us early so that we can provide all the interventions and even run career fairs or job fairs during lunchtime. No? So these are some of the more progressive practices which we have seen on the ground and which helps in the easing in. Because the last thing you want is the workers are high and dry. Yes, there may be retention benefits, but so what? You may not be able to land the next job. And I thought these are important points.
Okay. Thank you. The $1 million question. Do employees have a right to retrenchment benefits?
That is always such a tough question. Now, the thing about Singapore, the current legal landscape is that there is no legal right in the sense of like a statutory right to retrenchment benefits. The tripartite guidelines has recommendations. I would say which is about 2 weeks to a month per year of service. I mean, it's unfortunate, I mean, there's no statutory right to it. Sometimes you may see that right written into the contract. I would say it is maybe more common with contracts with perhaps multinational companies. By and large, most companies in Singapore do not have retrenchment benefits written into the contract. So really, you will be relying on, I hate to say this, but the goodwill of the employer when they are carrying out the retrenchment exercise. I would say that I think through the COVID-19 pandemic, I have seen several instances where truly the employer was not able to pay because of the financial situation of the company. And really, it was a decision made to stay afloat so that, not the entire workforce would be out of a job, but just part of the workforce. I mean, it is a very unfortunate decision that anyone has to make, but that was the situation. So, yes, unfortunately, the retrenchment benefits are not guaranteed by law. I think the best thing that the employee can do is what Patrick has said, which is notice, to give early notice to try to ameliorate the effects of it to the extent that they can. Because that is something that the employer can do. You see, it's not a financial outlay on their part, and it's really something that they can do for the employees.
And having come from the labor movement, join us as union members, because in unionized companies, we have something called a collective agreement. It's a word of court. And in all our collective agreements, we have locked in this provision of retrenchment benefits. So if your employment contract does not provide for it, not to move here, that's where the unions and our collective agreements come into action and play. And in fact, I have appeared before the Industrial Arbitration Court on a couple of instances over non-payment of retrenchment benefits, as well as not an agreeable amount of retrenchment benefits being paid out and not out of sync with industry practice. So that's important. And therefore, I encourage you all to be union members, and unionized companies, we try to have this collective agreement in force so that we can better protect you. Well, in the eventuality or in the unfortunate circumstance where there's a retrenchment that needs to be carried out. So that's also, in a way, provided in the tripartite advisory, the TAMEM, which we alluded to earlier. It does say 2 weeks to a month, and in most unionized companies, likewise, is about a month on average, depending on industry again. She made a very good point. Even in the Industrial Arbitration Court, besides industry practice, the ability to pay is very, very important. Because you can't, you really,
You can't squeeze blood from skin.
it's really tough. There may be instances where you may win the ruling, but the company may fold. So just take note of this additional point. But it just brings to mind actually another important point about how to make this a bit not just fair but responsible and progressive. It's particularly in Singapore. I think the timing of it. We communicate early, we give early notification, but please, employers out there, don't do it just before Chinese New Year and Christmas or you know why? I've actually encountered companies that do that. Just imagine Christmas Eve you get a retrenchment letter, or just before Chinese New Year. Why? Because our calendars run quite differently. Our lunar calendar runs quite differently from for example, maybe the American calendar, or the way business cycles and financial year ends varies from different countries, different jurisdictions. So bear in mind, if you're operating in Singapore, I think be sensitive about it, particularly for major festivities. Don't just do it on the date or just the day before. And, it's really a dampener. And what I worry most is not so much you executing it, and it's going to be a big reputational hit. And don't blame me if NTUC comes out and make a public declaration that you're not doing very responsibly and fairly and progressively. Yeah. So take note of that. This one takeaway I thought should advise those who operate in Singapore to do it compassionately as well.
Let's discuss a scenario now. This is a scenario when an employer terminates the contract by paying the contractual salary in lieu of notice to the employee, but the employee does not give a reason for the termination. Now, my understanding is this is legal most of the time. So in this case here, Irfan was terminated by his employer. They paid him salary in lieu of notice, which means that he would leave the company immediately and they'll pay him his 1 month salary. The company did not give a reason for the dismissal. But Irfan suspects that it's because of his age, because he's heard, talk in the office that the employer was referring to Irfan's age. And he was hoping to hire someone younger. So Wei, in this kind of case, how would it fit into the law, and what rights would Irfan have?
Okay, maybe to address the first thing that I see, and maybe that might be a question that comes to a lot of people's minds. Is it acceptable for an employer not to give a reason, but to just terminate by paying salary in lieu of notice, or just giving notice, and employing the employee throughout the notice period? Under our laws, it is acceptable to not give a reason. But I think in this case, the issue is that he has grounds to suspect that there's some discrimination. And if indeed it is discriminatory, then there can be grounds for making a claim for wrongful dismissal. Of course, the slight, I suppose the difficulty for the employee, though, is that the burden of proof is on the employee to prove that indeed there has been discrimination against him. But I think nonetheless, I think the point here is that if there's discrimination, then yes, it would constitute a case for wrongful dismissal.
Patrick?
Yeah, this actually brings to mind Section 14 of the Employment Act, something which Bob possibly we also very familiar with, and even as we are talking today, we have started a tripartite work group of reviewing the Employment Act. I declare my interest. I'm part of the tripartite work group as well, and we're looking at the various areas we want to review to make sure that the Employment Act, well, the last amendment was on the 1st April 2019, effective 1st April 2019, and it's been quite a while. Median wages have gone up, unique circumstances have arisen, there are various disputes that have come up along the way in the last 6-7 years. So it's time to review some of the provisions. So this is something that came up as well. As you know, contractual termination is permissible under Section 14 unless you prove that it was wrongful or unfairly done. And employers don't have to give reasons. So actually we are in discussion on whether should we mandate that reasons be given, because if many of you may not be familiar with Section 14, it allows for a termination of an employment contract. Like most provisions in the Employment Act, it's a reciprocal relationship, a reciprocal obligation and right. Meaning, if employer gives you 1 month notice, or you can give 1 month notice to employer to resign from your job and terminate employment contract. Likewise, the employer can give you a 1 month notice, pay in lieu as well, and then terminate you from the employment contract or terminate your employment. So that's not impossible, that's permissible. The question comes when there's no reasons given, and in this scenario, then of course we can make a claim and say, in a way, there are hints of wrongfulness and discriminatory practices. But however, in very clear, clean-cut situations where there's no reasons given and nothing surrounding circumstances, that's where we are actually in discussion with tripartite partners whether we want to mandate employers to give reasons. It cut both ways. It cut both ways. Why do I say that? We have encountered, personally as well, encountered situations of disguised retrenchments, meaning employers actually terminate using this provision, contractually terminate employees, but actually it's a redundancy situation. They're trying to weed off workers and lay off workers using this technique, so to speak. And that's not right, because when the redundancy situation, then the other things that we discussed earlier kick in. So that's one, we want to avoid that situation. However, of course, there may be a clear-cut situation where, this is just a pure ending of a termination of employment contract. It could be for a variety of reasons: poor performance, non-performance. The reason goes on. However, in a situation, for example, if it was very, very, very poor performance, consistently, not just for that year, but on multiple years and occasions, then we also don't want to force feed and include the reasons, because lo and behold, the employee, if he takes that termination letter and there's reasons there saying it's poor performance, you can imagine if he goes to the next employer or applies for the next job, if I'm going to show the next employer that piece of paper, or in most cases, the prospective employer would ask you, either in the interview or at the application process, the reasons behind you leaving the previous job.
Yeah.
So you'll be in quite of a difficult position. So that's why if you notice our employment laws tend to be a bit more, how I'd say, well, we provide some flexibility both ways for this very reason that we don't want to hardwire and cause more acrimony than solving things in a win-win way.
Yeah, that's absolutely true. So we had that conversation, right, where I asked you, it's a very strange situation where there's no reason given. But when you told me that, I said that is actually a very good reason that, this provision actually sometimes is protective of the employee. I think generally speaking, employers who seek legal advice, now if it's a case of poor performance, often the advice would be that you just terminate with notice, according to the contract. It is not so acrimonious, and I mean, it is, the presumption is that the termination will be legal. So which means that actually, I think very often when you see a termination with notice and no reason is given, very often it is a situation where the performance is not satisfactory. And it could be a situation where the actual job being done itself is not satisfactory. We also see some situations where sometimes they are unable to get along with their colleagues or their team members or with their superiors. So I think the problem is that once all these is put on paper, it will be difficult for
Very
the
prejudicial.
yeah.
It's very pushy.
And nowadays there is a lot. There's many employers who are actually ask us to be able to speak with someone from who is your supervisor, with your former employer. So I think that just opens up another can of worms.
So that's why in the labor movement and with our unions, usually we pay very particular, careful attention whenever we execute layoffs. We hear the reasons out. Or when employees are terminated, we do hear them out. There's a grievance procedure. We follow it quite closely, and to basically understand the reasons behind it, and therefore we try to come amicable settlement or conciliation. Because you're absolutely right, Wei. It may be the converse. It may not be a rogue employer. No, it could be really an employee who's really had not been performing up to mark. So we also want to better protect the worker so that he's not prejudiced in future job applications. So we will usually ask them to voluntarily withdraw their service. Or sometimes, companies do exercise this and say, why don't you just resign from a job?
Yeah.
Of course, remember, if it's really a disguised retrenchment situation, if it's a forced resignation situation, recourse is still available to you through the unions or through TADM.
Thank you. Thank you, Patrick and Wei. Running out of time, mindful that we are reaching the end of our session. So let's move on to some of the Q&As that have been asked. Thank you very much to the audience for giving us your questions. One question with a very high number of votes is this. Some employment contracts state the employee is not allowed to join a competitor after resigning. Is this valid? This is what we call a non-compete clause.
We could have a complete separate webinar on
Yeah, it will take about 5 hours. That means, or will.
Okay, we don't have a lot of time. I will not go into the intricacies and the technicalities of the law, but I think generally speaking, in the Singapore context, the courts are quite hesitant. They are quite slow to enforce this sort of non-compete clauses, which says that, you cannot work for a competitor for the next 6 months. Okay, because generally these clauses are considered unreasonable. I would caveat this to say that it's not that it is impossible to enforce. Usually, the courts will not be willing to enforce it. Everyone can see why it is unfair. It's difficult for the employee, putting somebody out of a job for 6 months. But I think in very select situations where the employer can prove that it really has, an interest that it needs to protect by doing this, then in those scenarios, the clause could be enforceable. But the general position is that they are not. Maybe just one catch I would say is that there is also a difference between a non-compete and a non-solicit clause, meaning solicitation of customers. They are still also subject to certain tests of reasonableness and whatnot. but it is not seen completely in the same light as a non-compete clause, because a non-compete puts the employee out of a job. You see, so I think that's a very big consideration that the courts have and the law has on this point.
Wei is absolutely right on point. You know that first principles contracts in restraint of trade are not enforceable. However, in some scenarios they've allowed it, maybe because of the nature of the appointment, the access to confidential information, customer list, and so all this seems to suggest that that position that of that particular employee needs to be reasonably influential and senior. Yeah. Why I need to emphasize this point? Well, I've started to see employers lock, stock, and barrel cutting and pasting restraint of trade clauses for their normal rank and file blue collar employees, it should not be the case.
Yeah, for example, like you can have the head chef having a non-compete. Okay, that may be reasonable. Then all the cooks also get the same.
A real case, a live case, a couple of years back was our private security officers. They are low wage workers, mind you. They're low wage workers, and what happened was this particular security officer was working for this particular security company in this particular location in town, and lo and behold, the company lost the security contract to another security company, and then the new security company took over the contract. But because the security officer has been there for 2 decades, looking after that premise, he's like, he can blindfold, and then he's so familiar with the place, and really, plug and play. He can really get into work very quickly and very productively. And lo and behold, when he started with the new employer, the previous employer kind of exercised the restraint of trade clause against him. And mind you, as private security officers are actually lower wage workers, so very unconscionable. I mean, how can you stop someone from working within a geography of 5 kilometers or with the same company for extended period of time? And this has not been tested in the courts. We nearly brought that case to court, but they sort of realized and withdrew that. So you could continue.
It can be enforceable.
Yes, of course. So therefore, for the benefit of the audience who are very excited about this topic, again, just as any other manpower and labor laws and policies, there's a tripartite discussion on this, and we will be. I think Minister has already shared it earlier this year. I raised it in the Committee of Supply, and there will be some form of advisories, guidelines, or some sort of code to provide more clarity and to elucidate this point on restraint of trade, and not so much on giving you new laws. Because contract and restraint of trade is usually tested in our courts and with the common law, and there's plenty of materials, but more to provide guidance and instruction that this is not right if you impose it on very, very general workers in general. I mean, not the top of the the hierarchy kind of professional manager executives, but or the general man on the street, the worker. Such clauses are too onerous and unconscionable. So look out for it. It should be out within this year or next.
Thank you. Let me move on to the next question. So it's quite common in Singapore where employees or pre-employment, they're asked they're given a pre-employment medical declaration. Do you have any illnesses? And some of them will be subjected to medical checks, like our case of Mary. But must we declare? Because people are afraid that the employer might use this to terminate their contracts, or worse, they get hired and then later on they get terminated.
I think this is something where the legislation, the newly enacted legislation will definitely possibly address. I haven't personally encountered such a case, but I would say, going back on first principles, if the employer asks you to declare, this is not statutory, it's not a statutory requirement. It is the employer asking you to do so, and you decide whether you want to do so. Of course, should you fail to declare something and the employer later on decides that, because you didn't declare and you have this condition, I will terminate you. Then the issue becomes, is this discriminatory, right? Because, that is one of the, for example, mental health conditions. That is something that is covered by the Act. So I think this would probably, in my mind, this would probably be how it plays out.
So it's better to declare.
Well, I think it depends on your comfort level. I mean,
Because if you don't declare, you might get in trouble later for not declaring. Also, right? It cuts both ways, I suppose.
yeah, but I suppose get in trouble. What do you mean by get in trouble? You see, because it's a situation where if the employer takes a decision against you,
Mm-hmm.
but which is discriminatory. So, I don't see how in that sense it's fair for the employee to say that, you're getting into trouble and you're going to lose your job because of that. If that's discriminatory, then this employee has recourse.
Yes,
Yeah.
correct.
There'll be in most companies the practice of sending their prospective employees for medical examination. So that's where, for a variety of reasons, to make sure that they are fit and able, not so much to discriminate against them, but they are fit and able. At the same time, also for
insurance.
injury compensation insurance purposes, because insurance law is another topic altogether on whether if you feel to declare particular pre-existing illness, etc. There may be attendant issues that they may come along the way, especially so when big organizations actually have big insurance brokers handling and underwriting some of these insurance packages for their staff. So these are some considerations.
Actually, I have a question. So if it's like just like Mary's case, of just a desk-bound job, it's not a physical, like manual labor sort of job. What's the take on sending an employee for a medical check? It seems unnecessary, does it?
So it varies on. There's nothing to stop, nothing to encourage, or it's just purely for
reasonable.
Yeah, it feels unreasonable, right? Because you're testing whether you're.
Correct.
But usually, I think most of the time is for companies, insurance as well, because you have a few sets of.
Going for medical isn't cheap. And so I assume, I've seen it being done from an insurance perspective because the insurer is paying, once to make sure that you're within coverage. So this also helps to manage the premiums that the employer is paying. Yeah, and you're right in terms of workplace. So for example, if you do have a pre-existing back injury and then you're doing heavy lifting, you didn't declare it, then you get injured while you're working. It's not really fair for the employer.
Yeah.
So these are the attendant issues. So not easy because what is discriminatory, what is not best practice, what is not. Certain aspects are still good points.
Yeah. And I suppose the nature of the job also matters a lot. Yeah.
Yes, that's true. Okay, well, sadly, we're out of time. I'd like to invite maybe just as a parting gift for all of you, maybe I'll ask each speaker to give us with one key takeaway that assuming you've not remembered anything in the last 2 hours, what do you want to go home with? One piece. Thank you.
Yeah, I will just say you never walk alone. Not that I support Liverpool. I mean, I do support Liverpool, but I think we have a lot of resources, a lot of help and schemes, whether with the unions, whether even if you are not a union member, there are even like through our Law Works partnership, etc., access to justice and assistance and advice as well, even free legal clinics. So I think make full use of these resources and speak to someone if you are unclear and you want to know your rights and privileges.
Well, I think for me, I think I've mentioned it earlier, which is really that. I mean, there's a whole host of guidelines and these information, they're all publicly available. I mean, these guidelines have been prepared and they've been very well thought out, and they have been prepared with the benefit of hearing the employer's perspective and the employee's perspective. So I would urge, employees and employers, familiarizing yourself with it is not just for the purpose of compliance, but I think it is a matter of managing expectations. And I think ultimately, both the business and the employees would benefit from understanding and complying with these guidelines, because I think it would, at the end of the day, produce a better and more harmonious work relationship between the two groups.
Well, thank you, Wei and Patrick, for sharing your knowledge and experience with us. And now I have to end our webinar. If you have, if you need legal guidance going forward, do write to this email address, help@probono.sg, and I'm sure someone will get in touch with you from the Pro Bono Singapore team. Our next webinar will be Neighbors in Dispute, What Are My Legal Options? This happens tomorrow, Friday, 26th of September at 7:30. The session will cover how the law addresses common neighbor disputes and when mediation might be the better route. The speakers will share real case studies and useful strategies to manage difficult situations without escalating them. So whether you're facing a problem now or you want to be better informed, I'm sure this webinar will leave you with clear, actionable advice on how to resolve disputes and protect your peace of mind. This and many more webinars are part of Law Awareness Weeks at CDC 2025. And you can click on the link shared at the chat function to visit the website to register for the next webinar or webinars that interest you. If you missed any of the webinars and wish to catch up on the ones that you have missed, the recordings of all the Law at CDC webinars will be made available on Pro Bono SG's YouTube channel 2 weeks after the end of the live webinar. You can check out the channel on YouTube for this. With that, on behalf of Pro Bono SG and our panelists, we would like to thank you all for joining us today and have a good week ahead. Bye-bye.
Thank you, everyone.
Thank you.